Good afternoon. I am Vincent Sarroino from GroupeSarroino, Keller Williams. I am here today with Mariana Valente Mocelin, Notary Mariana Valente Mocelin. Welcome.
Thank you so much for having me.
Thank you for being here. I'm going to just open up with that notaries play a crucial role in the responsibility of residential real estate transactions. They're all done through a notary. Yeah. As a legal professional, I believe you have responsibilities, both buyers and the sellers, and for these transactions. And we're going to discuss some of the key legal responsibilities of the notary to both parties. Yeah. So with that being said, if you can basically just maybe share a little bit of your profile as a notary in terms of what the services. So I know you don't only do deeds of sale and transactions. That'll be fundamentally what we'll be discussing. But I'd like to just hear, your profile.
Thank you. Yes.
And share it with our audience. Yes.
Yes, my name is Mariana Valente Mocelin. I'm notary, offering my services here in Montreal. I have the clientele from the West Island, from the point of view more English speaker clients. For the close to Mont Royal office in Park Avenue, I offer the services for the clientele, also English speakers, but more in French, because we have much more French speakers and French immigrants in that area. Yes. I am Brazilian, so I have a lot of clients that speak Portuguese from Brazil, Angola, whatever country, Portugal, of course. So basically, I offer the traditional practice, is what we call in notarial field, which means real estate transaction, yes, a lot, but the real estate transaction leads to other kinds of fields as well. We work with estates, estate planning as well, with wills, protection mandate in case of incapacity, all the other documents, let's say, to protect the public, general power of attorney, when it becomes the time to enforce the protection mandate, I also have the accreditation to do that. Okay. So it's all kind of notarial practice that we offer.
So that's great information, because I don't think a lot of people understand fully the notary's role versus a lawyer's role. Both are legal.
Yes.
But yours are very specific, and especially in Quebec, because it's unique to Quebec, the notaries. So that being said, thank you for that information, and I believe a lot of viewers who will be viewing this will take note of all the services that you have, and I hope they will call you. So
Thank you. My pleasure.
That being said, we'll start off right away. And Mariana, ensuring legal compliance. What does that entail, and can you explain briefly?
Legal compliance, it means first Quebec's law, some regulations. Let's say we talk about also municipal bylaws. So we make sure that when we will work in the real estate transaction, all the rules are respected. Also, the requirement for the financing are respected. So there are several aspects that we need to take into consideration to ensure a really good real estate transaction. It passes also through what we called a title examination. So to ensure to the new purchasers that the property that the purchaser is buying is free of charge, free of mortgages, free of any lien that can affect their ownership rights after. So the notary goes on the land register, examine the titles, examine the certificate of location. So this is what we call to ensure a secure, legally secure transaction for the buyers, but also for the vendor, because we don't want the vendor in the future be liable for a transaction that they thought that they sold a property that was with good title, but and have bad surprises after. So that's the reason why also the notary works as an impartial professional to secure the property, the transaction, and also the parties.
Yep.
Yeah.
That's great information. Thank you for that. I have a subsequent question to that one.
Yeah.
You talked about making sure that everything complied, and also in terms of financing and I guess certificate of location.
Yes.
Once there is an issue, in what instance would you use title insurance, for example?
Very, very good question. Very good question, because some people simply require the title insurance because they heard in the publicity, the marketing, they read on the newspaper some horror stories. Usually the title insurance we talked about when first there is a problem with the title. Okay, it can be many kinds. I can give some examples, but basically this information when we see a problem in the title. And in this case, we always have to try to fix the problem, not only offer the title insurance. And when we have to fix the problem, is the seller that we're going to approach first to explain the situation before informing the purchaser. When the seller, for any reason, cannot fix the problem, or the problem maybe is there even before he acquired the property. So in this case, we try to see if we can fix before our sale, or if there is no fix, or the risk can be lower, or we have to evaluate, of course, each kind of file, but in certain situation, we're gonna talk about the title insurance to cover eventual title problems,
damages, yes.
right? And when we do that, it's important for the purchaser to understand that in the future, if the situation is not fixed by the time that the purchaser will sell the house or the property, this will be a discussion that the purchaser today becomes seller in the future will have to have.
That's right.
Okay, so this is one situation, but the other situation is because we don't have, for example, the certificate of location describe the current state of the property. So this is a very common when we have the urgent file, the transaction that must be done very in a hurry because the parties, they don't want to wait.
Okay.
And we don't have the proper certificate of location. So in this case, we need to advise everybody the importance of having a good certificate of location, describing the current state at that moment on the transaction. But if the parties, purchasers and sellers, they really want to pass the transaction, we have to have a release of responsibility and offer them the possibility to subscribe a title insurance for that.
And that title insurance will protect them, both parties, to the agreement for pertaining in detail of what they agreed to for a certificate of location to be provided at a later date.
Exactly, for the potential risks that could cover in the new certificate of location. Or according to situations, let's say that the certificate of location being old cannot reflect the reality today. For any reason, a defense or a new construction close to the waterfront or these kind of things.
In most cases, you would prefer probably to wait or to delay if you could, probably, right?
For sure.
Yeah. Okay.
Because as notary, what we want, we always cherish, of course, a happy real estate transaction because it should be a happy moment for everybody.
Absolutely.
But also we need to legally secure the transaction. So
that's good. Perfect. That's great. Thank you so much for that information. So continuing, drafting and reviewing documents. Can you please elaborate on a succession sale, power attorney, mandatory, liquidator of estate, and what their roles are and responsibilities? And what would you advise in those circumstances?
Yeah.
Are there multiple visits involved? It could be complex. I've been involved in quite a few of them with you as well. So if you can summarize those and to the best, I know it's a lot. We could probably just do one segment on this.
Yeah.
But if you can...
This is a very important, and I feel very glad that I saw this, the question coming out, because it's unfortunately very common to have this kind of transaction when the people, they don't have the proper documents, because sometimes because they don't know, because sometimes they are not dealing with professionals since the beginning. As we see, there is some real estate transactions done directly between the people. So this just increase the risks of having this kind of bad surprises in the file. This document that you mentioned, the power of attorney, protection mandate, the liquidator itself, who is this person? So this situation, this transaction when we need this kind of document, there is always something related to the capacity or representative of the parties, right? And especially sellers, okay? So this is what happens when sellers, let's say, would like to sell using a power of attorney. A power of attorney can only be used while the person is still capable, because the notary must be able to validate. We understand that if you sign the power of attorney is to appoint someone to go to the notary's office and sign the paperwork, but the notary, we need to reach this person to validate the seller's capacity to act, to understand. If we call, by calling the vendor, we see that the vendor cannot answer basic question where he lives or this kind of things, or what is the address of the property they are selling. Yeah. So we cannot proceed in this transaction. So this is a very sad surprise for the purchasers, also because sometimes the purchaser make plans and then we have to postpone the transaction or sometimes even cancel. For the protection mandate, is also very important to understand the difference between power of attorney and protection mandate in case of incapacity. Because what I see very often, but I'm only one notary, imagine the others as well. So people decided to sell a property when the seller is not fully capable anymore, using a protection mandate non-homologated. So homologation of the protection mandate is a procedure that we need to go to court. It takes time, it takes assessment, medical and psychological assessment. So it's a procedure that not necessarily when we sign an offer to purchase and then this offer to purchase is final, if all the conditions are fulfilled, we cannot come back with the purchaser, so it's very complicated, this kind of files to manage until the end. Yeah. And what I think is most important is people to understand when we have a protection mandate, first identify a protection mandate versus a power of attorney. And when we're gonna use this document to make sure how about the capacity of the person who signed, who gave these powers. So to avoid surprise when the notary called to the vendors.
And how important is it that we can't predict when a loved one's going to pass away, or and when these things are going to be incapacitated? Yeah. So how important do you believe is to have these conversations among family members or the person that's going to be mandated?
For sure.
What would you recommend to the viewers watching this video in that case?
Okay, when it's case of death, and of course we don't know or we are not expecting, we just of course have to deal with the situation according to the level of preparation of that seller or that party, right? Of course, when we sign a promise to purchase while we are still alive and in good health, and by the time that there is the deed of sale, the closing date, if something happens, a death happened meanwhile, unfortunately the state is bound. We need to pass the transaction and according to what was decided. Yeah. And the proper documents will have to go along. In order to get really protected, of course, everybody must prepare a will. So we know exactly what will happen after, who will be our representative, which means the liquidator, preparing the power of attorney, general power of attorney, and the protection mandate, also very important. Incapacity can happen. We never know how fast the disease will develop. Yeah. We don't know if it will be an accident, for example. The power of attorney is important to understand that while you are still able to act by yourself, maybe you don't feel the need to have a power of attorney prepared, but really between this moment, a capacity versus incapacity, there are some procedures that can be made if we have a power of attorney to continue giving the effect to be used and complete your plans.
Yeah, well, that's great information, and I hope to cover this again with you, and we'll go more in detail. But thank you for your answer on that. Yeah. When explaining legal implications, can you briefly explain the legal implications of the documents involved in the transaction actually itself, from accepted final offer to purchase to fulfillment of conditions, the title examination, the certificate location, and therefore, and so on. So if you can just elaborate on this.
Yeah, of course, the promise to purchase, accepted one, of course, which means all the conditions fulfilled. The conditions being inspection, condition being financing. So when the file is complete in that level, usually with the assistance of the real estate brokers, this sale is final. It's just, of course, the work of the notary that starts after to make sure that the property is everything complying as well. So when we do that, we check the certificate of location, and we check also the land register. We do the title examination to ensure that the property is complying in all aspects.
Clear and free as well.
Clear and free, exactly. Yes, we communicate with the bank of the vendors, because usually most of the transaction there is a mortgage to close. That's right. So we make sure this mortgage is closed. So we talk about the discharge, the release, of that mortgage. We also work with the new bank, the purchaser's bank. So we have all the paperwork to be signed. And what is important here that I think that I would like the public to understand really the difference between mortgage and also loan agreement, because sometimes people think that they signed the mortgage with the bank, but no, mortgage is only with the notary. That's right. Right? So the loan agreement is very important, people to get fast whenever the promise to purchase is signed, to go to talk to the bank as soon as possible and request an appointment to finalize the loan agreement, which means exactly to confirm the terms and conditions, the interest rate, the frequency of payment. This is at the bank that the client will do that. With the notaries, 1 week before the transaction, we sign all the paperwork related to the the mortgage of the property. And of course, all the documents related to the promise, the deed of sale, the adjustments, tax adjustments, condo fees adjustments, whatever repairs that will happen on the property, so notaries can hold back the funds. So this will be based
for a stress-free transaction, and it's not always the case. Especially on the part you talked about, the mortgage, the banks take their time in some instances to send the instructions that you've requested. And I've actually dealt with something most recently. It was delayed by almost 15 days further than it was supposed to. So, it's creates stress on everybody, the collaborating brokers, the vendors, the buyers, everybody. So this is really important that you mentioned this, and because the seller and the buyers can help themselves in the process.
For sure.
They can't only rely, and obviously as a broker that's a knowledgeable broker, I feel it's part of my responsibility to make sure that they understand what their rights and what they have to do, and to maybe impress upon them to make sure they take that action.
Exactly.
Or speak to the notary, and the notary will guide you to what you have to do. Yeah. So thank you for that.
Yeah. Can I add a delay?
Absolutely.
Important?
Absolutely.
Because when we have the closing date, people must understand that we need to sign the mortgage 1 week before this closing date. So which means in order to the notary to prepare the documentation for the mortgage, it means that we need to receive the file at least 2 weeks before the transaction. This is important. And also in terms of payment of the down payment. So everything happened, the financial portion of a transaction must happen 1 week before the closing. So that's why it's fundamental that the client contact their bank as soon as possible when the promise to purchase is final, which means all the conditions fulfilled.
Yes, absolutely. And as a listing broker, which I do quite a bit, it's very stressful on the seller because we're at the mercy of a collaborating property broker and a purchaser to do their process.
I imagine.
And following up is not always easy to do. And I don't think anyone has bad intentions. I just think that that's why I'm glad you're repeating it, and when whoever's watching this will including my colleagues that I work with, it's important, including myself, and I'm really on top of that. I'm very aware of it when I'm representing the buyer. I always make sure I'm trying to make your job as easy as possible as well. So
and less stressful for everybody. Clients happy, right?
Yep.
If the clients are happy, we are happy as well,
Absolutely.
right? Because everybody can work better.
Yes.
Yeah.
So Mariana, ensuring consent and understanding, is this done separately before the deed of sale? And could you elaborate a little bit more what that entails? And I know it's important. Consent and understanding is self-explanatory, but maybe you can just elaborate on to what point.
Yeah. The consent we obtain for a first contact with the client, and usually it happens over the phone, right? And of course also by exchange of emails, we try to really talk to all the parties, even though let's say it's a couple who are selling or purchasing, so we try to reach, we know that certain organizations in the family, they will delegate this paperwork or the contact with the notary with between one of them. But basically the consent is fundamental for our professional. We need to make sure that everybody consents, agree. It doesn't mean only the parties, but also let's say the spouses who are married under their matrimonial regime, they need to consent to the transaction as well. In terms of presential versus remote meetings, according to the new change of laws, it's possible to sign virtually just under certain circumstances. Must be exceptional, and this exception character must be evaluated according to each file.
Okay.
So it's not the rule or just a request or simply request anymore. The client must come to the office of the notary, and we pass through all the documents together, and we sign usually, mostly now remotely, even though we are in physical presential of the client.
Yep.
And yes, all the parties must be present virtually, remotely, or in person.
Okay, that's great.
Yeah.
Thank you. So witnessing signatures.
Yeah.
Does this always require parties to be present at the signing? So you've answered this in part as well. So maybe, I don't know if there's anything more that you want to elaborate on this?
Yeah, there are some exceptions actually, when the person doesn't need to be herself or himself in presence or signing the documents, is in case of where they are represented, all right? Represented by an attorney through a power of attorney. Power of attorney general or specific, can be a power of attorney just for the sale, for example, right? Through a protection mandate, let's say, so where the person who comes to the notary's office is the mandatory, right? Appointed on the protection mandate, which is homologated before, prior the transaction, right? And sometimes by the liquidator, Okay, or a representative, for example, for a minor child who is somehow owner of a property, or sometimes is also an incapable person who has a tutor appointed according to this procedure, also to appoint someone to represent that person. So the person itself doesn't necessarily need to be present, but must have the proper documentation to allow someone else.
Yes, it's complex, and again, we'll actually do this again, and we'll go more in detail what that means again and what it implies. Recording and registration. When does this take place during the deed of sale process? At what point, and what is actually done by the notary? Yeah,
this is very important information, I think, as well, because the registration, of course, always happens after we sign a deed of mortgage, the hypothec, in the first moment. So the first document that we sign and re-register. This happens 1 week before the sale, so the clients, they're not worried about that. They're more worried about the second registration that happens with the deed of sale. Why? Because it's after that meeting, after that registration, is when the notaries can release the funds, reimburse the mortgage. So at this registration of the deed of sale, people are more interested, right? So what we always explain is the registration process. It's held by the Land Register of Quebec, and usually it takes 2 business days. So when we send the documents for a registration, we receive a confirmation 2 business days, usually 48 hours after. So it's important to understand these delays when we are selling and purchasing right away. So technically, we cannot purchase if we don't have the funds available for the previous sale.
Yes, I've been in many circumstances, including with yourself, where that is happening, and there's more than one transaction going. And whereas myself as a realtor, I try to promote one notary to handle all the transactions.
Exactly.
So you can be in control how everything goes and flows.
And the delays, right?
I highly recommend to the viewers to always agree in this process amongst all the parties. So absolutely.
Exactly.
So Mariana, we're going to discuss now escrow services, and under what extenuating circumstances, is this required and why? So I know you provide these services, and it could be complex. So if you can briefly just touch on it. And,
I would have 2 examples that we see more often. Is repairs to be done on the property by the purchaser, by the vendor after the sale. Sometimes in the inspection report, it's revealed some repairs, works on the property. Some of them can be simply recommended, but some of them, they must be repaired before certain time because it represents a risk to the property.
Absolutely.
According to what has been negotiated between the parties, yes, it happens that there is this request to hold back funds for example, to fix the problem, or sometimes it's something that we need to wait until the next season because for the snow, for example, we cannot fix the roof, just an example. So the hold back funds is very common, and what the client must understand is be flexible according to certain terms used on this kind of agreement. For example, at the satisfaction of the buyer. So this is, I don't mean that the buyers don't need to be satisfied with the work, of course not. But what happens very often is the buyer can go further in their interpretation of satisfaction. and it can create issues between the parties. And according to the funds, whenever the funds are held, which means the vendor cannot have this money, and if the work is done by professionals,
Yep.
so the buyers
And he's
must
provided proof of.
and the purchaser visit the property, or sometimes they delegate that to their broker. So just be flexible and do not abuse of this term of satisfaction of the buyer.
Yeah,
Okay.
absolutely. And they have to
Right.
understand that it's a legal transaction that both parties have to agree to. And you're right when you said we write clauses sometimes because it's by default we write those
For sure.
and they can be taken out of context.
Exactly.
So satisfying to the buyer's satisfaction means that the job was completed by professionals. It was done. It's complete. Now this condition is satisfied, and the buyer
funds can be
has the proof, and now the funds can be released to the seller.
Exactly. Yeah.
So
This is one example. The second example that is very common, it happens with common law spouses that are purchasing a property, and they have different down payments or different engagements. So this can be something else that we have to deal before the transaction. Usually we are not in the litigious situation. Really, it's very simple to identify because we always request the proof of provenience of funds. So it's something easy to discuss with the purchasers, but this is an example of extra procedure that we can do and put on the deed of sale this kind of agreement, because in the future when the property will be sold, the next notary can respect this agreement and pay the percentage to the right persons, right?
And obviously we don't wish anything to go wrong, but life happens sometimes, and parties can break up. They can be a divorce. There's a lot of things that go along with that. So it's good that it's clear.
Exactly. Since the beginning, since the purchase.
Exactly.
Right.
So thank you for that.
You're welcome.
And last, conflict resolution. So when you cannot advise to resolve a situation, what do you recommend the parties to do? Can you explain a situation where this may happen?
During the process between the sale, it depends on the stage, all right? When it happens, for example, the offer to purchase is final. All the documentation has been examined at their satisfaction, purchaser, buyers, right? Purchaser, buyers, and sellers, actually. But sometimes before the deed of sale, it happens something. For example, if we're talking about condo, right? Meanwhile, a special assessment can be approved, right? And a special assessment for something that wasn't really foresaw at that time when we signed the promise to purchase. This kind of it can generate conflicts between parties. Even though we have the Civil Code of Quebec saying who will be responsible in certain situations, but when we use a little bit of, we try to balance the financial impact for both parties. Some negotiation must be reopened between them. As notary, we cannot be involved, of course not. And for this reason, we send
back to me,
back to the brokers.
I was waiting for that. Yes, I've done it. I've done it several times.
Yeah.
Especially in the condo situation, especially if the occupancy is a little bit later.
Yeah.
And their AGM or their minutes or their they don't have all the documents in order.
Yes, exactly.
I have a case in fact that is going to be like that. I think that's going to come forward. There's a delay of 4 months before occupancy.
Yeah.
And they did not finalize their meeting.
Yeah.
They're from the last year.
Yeah.
So we've signed an amendment to detail this.
To compose, exactly.
To compose, exactly.
Yeah,
So, yeah. So in closing, thank you for all that information. That was like really, really interesting conversation. I hope the viewers appreciate what we discussed today, and will reach out to you and reach out to me as well. And I hope they'll take away. If they take away one thing from it, then we're better for it and helping the people and the public. So that being said, overall, notaries in Quebec must act in the best interests of both parties, buyer and seller, ensuring that a residential sale is conducted legally and ethically. I thank you again for your useful information.
Thank
and
you.
if you want to reach Mariana, please download the book at the end of this video. Go to the resource section, look for Mariana's information, contact her. I'm sure she'll be very happy to give you all her expertise and her knowledge and help you through your next transaction. Have a great day.